Hi, my name is Eric Peterson. I'm a lawyer at Velletta and Company practicing employment law. Today we're going to talk about another employment law topic, which is constructive dismissals. Now, a constructive dismissal is really just a fancy way to say, I quit to your employer, but to also, at the same time, exercise and enforce all of the rights that you would have if you were an employee who was fired without cause. So, the general rule of thumb in British Columbia is that an employee who quits their position isn't going to be entitled to any severance pay or any notice. They're walking away from the job and, that's on them. But constructive dismissal is a very specific category in the law that allows an employee who quits to bring a claim against the employer for severance. The idea is that although the employer hasn't fired the employee, they have, by their conduct or the way that they might have changed the employee's workplace or duties, changed their employment such to the point that they've pretty much been fired and have all of the rights of a fired employee. So not every minor change that an employer might make to an employee's employment contract or to their workplace will result in an employee having the rights of a constructively dismissed employee. So a really obvious example would be if you were a CEO one day and then you showed up the next day and you were demoted to janitor. Well, you haven't been fired, but you've pretty much been fired, so you have all of the same rights to claim for severance as an employee who has been fired. But not all cases are that black and white. And there's a lot of gray area, so it's important that you do consult a lawyer before exercising the option of constructive dismissal.